Hello everyone. In this video, we will discuss case laws related MCQs of Constitution of India. I have already made part 1 and 2 of this series. Do check them out. And here we will discuss MCQs of fundamental rights. And today's topic is Right to Equality, Article 14. Question number 1. Carry forward rule was held to be ultra vires in the case of Option A. Devadasan versus Union of India. Option B. B.N. Tiwari versus State of Mysore. Option C. State of Kerala versus N.M. Thomas. And option D. Balaji versus State of Mysore. The correct answer is option A. Devadasan versus Union of India. Question number 2. After which one of the following Supreme Court decisions was the special provisions for socially and educationally backward classes introduced by an amendment of the Constitution of India? Option A. D.P. Joshi versus State of Madhya Bharat. Option B. M.R. Balaji versus State of Mysore. Option C. State of Madras versus Champakam Dorairajan. Option D. T. Devadasan versus Union of India. The answer for this question is option C. State of Madras versus Champakam Dorairajan. Question number 3. It has been said in many cases with Devadasan versus Union of India that Article 16 should be read with option A. Article 45 and 332. Option B. Article 46 and Article 335. Option C. Article 15 and Article 332. Option D. Article 46 and Article 332. The correct answer is option B. Article 46 and 335. Question number 4. In which of the following cases the Supreme Court held Article 16 Clause 4A providing for reservation in promotions is a enabling provision? Option A. Keshavananda Bharati versus State of Kerala. Option B. M. Nagaraj versus Union of India. Option C. State of Kerala versus N.M. Thomas. Option D. TMA Pai Foundation versus State of Karnataka. Correct answer is option B. M. Nagaraj versus Union of India. Question number 5. Rajiv Kumar Gupta versus Union of India 2016 deals with the reservations in the state services for A. Persons with disability, B. Women, C. Other backward class, D. Scheduled Caste and Scheduled Tribes. Answer is A. Persons with disability. Question number 6. Which of the following cases is popularly known as the Hon'ble Case? Option A. TMA Pai Foundation versus Union of India. Option B. Ashok Kumar Thakur versus Union of India. Option C. Indra Sawhney versus Union of India. And option D. None of the above. The answer is Indra Sawhney versus Union of India. Question number 7. In which case the Supreme Court has held that the maximum limit of reservation cannot exceed 50%? Option A. Devadasan versus Union of India. Option B. Indra Sawhney versus Union of India. Option C. Balaji versus State of Mysore. And option D. Pradeep Jain versus Union of India. Correct answer is option B. Indra Sawhney versus Union of India. Question number 8. Mention the chronology of the following judgments of the Supreme Court of India starting from the earliest up to the latest case using the codes given below. Option 1. Akhil Bharatiya Soshit Karmchari Sangh versus Union of India. Option 2. Indra Sawhney versus Union of India. 3. M.R. Balaji versus State of Mysore. 4. AIMS Students Union versus AIMS. So in this case, the first case here is M.R. Balaji versus State of Mysore. It was held in 1963. The second is Akhil Bharatiya Soshit Karmchari Sangh versus Union of India. It was held in 1980. The third case here is option 2, that is Indra Sawhney versus Union of India. It was held in 1992. And the last is AIMS Students Union versus AIMS. It was held in 2001. Question number 9. The Supreme Court of India has adopted new approach for the interpretation of the concept equality in A. State of West Bengal versus Anwar Ali Sarkar. Option B, E.P. Royappa versus State of Tamil Nadu. Option C, Keshwananda Bharati versus State of Kerala. Option D, State of Karnataka versus Appa Balungale. Answer is option B, E.P. Royappa versus State of Tamil Nadu. Question number 10. Supreme Court decision in Srilekha Vidyarthi versus State of Uttar Pradesh is based on option A, right to equality under the Article 14 of the Constitution of India. Option B, right to contract with anybody irrespective of gender and sex. Option C, right to practice as advocate. Option D, right to claim damages and compensation. It was a leading case law about right to equality under Article 14 of the Constitution of India. Question number 11. The concept of equality as an antithesis of arbitrariness was propounded first by the Supreme Court in which one of the following cases? Option A, Ramakrishna Dalmia versus Justice Tendulkar. Option B, Maneka Gandhi versus Union of India. Option C, E.R. Royappa versus State of Tamil Nadu. Option D, State of West Bengal versus Anwar Ali Sarkar. Correct answer is option C, Royappa versus State of Tamil Nadu. Question number 12. It has been held by the Supreme Court that appointment of the candidates in excess of the notified vacancies is a denial of the and deprivation of the fundamental rights under Article 14, read with Article 16 of the Constitution in option A, Kerala Public Service Commission versus Dr. Kanjamma Alex. Option B, Ashok Kumar versus Chairman Banking Service Recruitment Board. Option C, State of Karnataka versus A.B. Ongle. Option D, M.D. Kasekar versus Vishwanath Pandu Barde. The correct answer is option B, Ashok Kumar versus Chairman Banking Service Recruitment Board. Question number 13. In which one of the following cases the Supreme Court has declared Article 15 Clause 5 as constitutional? Option A, Indra Sawhney versus Union of India. Option B, Ashok Kumar Thakur versus Union of India. Option C, State of Madras versus Champakam Durarajan. Option D, TMA Pai Foundation versus State of Karnataka. Correct answer is option B, Ashok Kumar Thakur versus Union of India. Question number 14. In which recent case the Supreme Court held that the transgenders fall in the category of socially and educationally backward classes, SEBs? Options are Nalsa versus Union of India. Option B, Dasarath Singh Roop Singh Rathod versus State of Maharashtra. Option C, Arunesh Kumar versus State of Bihar. Option D, none of the above. The correct answer is Nalsa versus Union of India. Question number 15. After which one of the following Supreme Court decision was the special provision for socially and educationally backward classes introduced by an amendment of the Constitution? Option A, Balaji versus State of Mysore. Option B, State of Madras versus Champakam Durarajan. Option C, Devadasan versus Union of India. Option D, Peraikarappan versus State of Tamil Nadu. The correct answer is option B, State of Madras versus Champakam Durarajan. Question number 16. In Indra Sawhney versus Union of India case, the Supreme Court has held that there A, can be reservation in promotions, B, cannot be reservation in promotions, C, can be reservations in promotion for other backward castes, D, can be reservation in promotion for women. The answer is B, cannot be reservation in promotions. Question number 17. Under one of the following judgments, the Supreme Court directed the government to constitute a permanent body in favor of the backward classes. Options A, Minerva Mills versus Union of India. B, Golaknath versus State of Punjab. C, MC Mehta versus Union of India. Option D, Indra Sawhney versus Union of India. The answer is option D, Indra Sawhney versus Union of India. Question number 18. In which case did the Supreme Court observe equality of opportunity admits discrimination with reason and prohibits discrimination without reason. Option A, State of Kerala versus N.M. Thomas. Option B, Air India versus Nargis Mirza. Option C, Ajay Hasia versus Khalid Mujib. Option D, Anwar Ali Sarkar versus State of West Bengal. The correct answer is option A, State of Kerala versus N.M. Thomas. Question number 19. In which case the Supreme Court has held that the maximum limit of reservation cannot exceed 50%? A. Devadasan versus Union of India. B. Indra Sawhney versus Union of India. Option C. Balaji versus State of Mysore. D. Pradeep Jain versus Union of India. Answer is option B. Indra Sawhney versus Union of India. Next question. In which of the following cases the traditional concept of equality was not accepted by the Supreme Court and a new concept of equity was adopted by the Supreme Court? Option A. Kedarnath versus State of West Bengal. Option B. State of West Bengal versus Anwar Ali. Option C. Balsara versus Bombay State. Option D. E.P. Royappa versus State of Tamil Nadu. Correct answer is E.P. Royappa versus State of Tamil Nadu. Question number 21. Creamy layer rule excluding the well-placed members of a caste from reservation was first laid down in the case of A. Ashok Kumar Thakur versus State of Bihar. B. Maneka Gandhi versus Union of India. C. Indra Sawhney versus Union of India. And D. Minerva Mills versus Union of India. The option is C. Indra Sawhney versus Union of India. Next question. Balaji Raghavan versus Union of India 1996. Supreme Court is related with which of the following article of the Constitution of India? The answer is Article 18. Question number 23. In E.P. Royappa case, which of the Supreme Court judge propounded the new concept of equality as equality is a dynamic concept with many aspects and dimensions and it cannot be crippled, combined and confined within traditional or doctrinaire limits? Options are A. Justice Y.V. Chandrachud. B. Justice P.N. Bhagavati. C. Justice V.R. Krishna Iyer. Option D. Justice O.P. Chinnappa Reddy. The correct answer is option B. Justice P.N. Bhagavati. Question number 24. In which one of the following cases has the Supreme Court upheld the constitutional validity of the Constitution 93rd Amendment introducing Article 15 Clause 5? A. TMA Pai Foundation versus State of Karnataka. B. Indra Sawhney versus Union of India. C. M. Nagaraj versus Union of India. D. Ashok Kumar Thakur versus Union of India. The answer is C. M. Nagaraj versus Union of India. Question number 25. Right to eligible employees to be considered for promotion is virtually a part of fundamental right of employees was decided by the Supreme Court in A. Union of India versus Hemraj Singh Chauhan. B. Supreme Court Employees Association versus Union of India. C. John Wellamaton versus Union of India. D. St. Stephen's College versus University of Delhi. The answer is A. Union of India versus Hemraj Singh Chauhan. Question number 26. Catch-up rule in relation to reservation was evolved by the Supreme Court in options Union of India versus Veerpal Singh. B. Indra Sawhney versus Union of India. C. Ashok Kumar Thakur versus Union of India. D. M. Nagaraj versus Union of India. The answer is A. Union of India versus Veerpal Singh. Question number 27. The claim of members of scheduled castes and scheduled tribes in making appointments is required to be taken into consideration consistently with the maintenance of efficiency in administration is provided under which provision of the Constitution of India or judicial pronouncement? Option A. Balaji versus State of Mysore. Option B. P. Rajendran versus State of Madras. Option C. Article 335 of Constitution of India. And option D. Article 16 of Constitution of India? The correct answer is option C, Article 335 of the Constitution of India. Question number 28. The Supreme Court of India in one case observed that Article 15 Clause 4 is a enabling provision and the state government is the best judge to grant reservation for SC/ST backward class categories at postgraduate level in admission and for the decision not to take any provision for reservation at the postgraduate level suffers no infirmity. This observation was made by A. Justice K.G. Balakrishnan in Ashok Kumar Thakur case 2008. B. Justice B.P. Jeevan Reddy in Indra Sawhney case 1993. C. Justice P. Satyasivam in Dr. Gulshan Prakash case 2009. D. Justice S.H. Kapadia in M. Nagaraj case 2006. The answer is C. It was by Justice P. Satyasivam in Dr. Gulshan Prakash case 2009. Next question. In which case the Supreme Court held that the rule that though reservation under Article 16 Clause 4 should not exceed 50%, it is not necessary to put out of consideration certain extraordinary situation inherent in the great diversity of this country and the people. It was held in A. Indra Sawhney vs. Union of India, B. Ashok Kumar Thakur vs. State of Bihar, C. State of Kerala vs. N.M. Thomas, D. Balaji vs. State of Mysore. The correct answer is option A. Indra Sawhney vs. Union of India. Question number 30. In which case the Supreme Court upheld the validity of the constitutional amendments providing for reservations in promotions to certain categories of persons? A. Ashok Kumar Thakur vs. Union of India, B. M. Nagaraj vs. Union of India, C. Indra Sawhney vs. Union of India, and D. Som Prakash vs. Union of India. The correct answer is option B. M. Nagaraj vs. Union of India. Question number 31. In which case has the Supreme Court of India decided that the reservation should be less than 50%? Option A. Champakam Dorairajan vs. State of Madras. Option B. M.R. Balaji vs. State of Mysore. Option C. R. Chitralekha vs. State of Mysore. Option D. None of the above. The correct answer is M.R. Balaji vs. State of Mysore. Question number 32. Which of the following statements is incorrect in view of the judgment in Pramati Educational and Cultural Trust vs. Union of India 2013? Option A. Article 15 Clause 5 does not violate the freedom of private unaided educational institutions under Article 19 Clause 1 Clause G of the Constitution. B. Article 15 Clause 5 and 21A do not alter the basic structure of the Constitution and are constitutionally valid. C. A law made under the Article 15 Clause 5 of the Constitution shall not be open to challenge and under Article 14 if it treats private aided and unaided educational institutions alike. Option D. Article 15 Clause 5 insofar as it is applicable to minority educational institutions referred to in Article 30 Clause 1 of the Constitution is ultra vires the Constitution. The correct answer is option D. Article 15 Clause 5 is insofar is inapplicable to the minority educational institutions referred to in Article 30 Clause 1 of the Constitution is ultra vires to the Constitution. Question number 33. In which of the following cases the reservation for Jats was struck down? Option A. Ram Singh vs. Union of India 2015. B. UP Power Corporation Limited vs. Rajesh Kumar. C. Prem Kumar Singh vs. State of UP. D. Dr. Gulshan Prakash vs. State of Haryana. The answer is A. Ram Singh vs. Union of India 2015. Question number 34. With reference to the constitutional validity of Section 377 of IPC, in which of the following case it was observed that sex under Article 15 of the Constitution includes sexual orientation? A. Nas Foundation versus Government of NCT Delhi. B. Suresh Kumar Kaushal versus Nas Foundation. C. Govind versus State of MP. D. Francis Corelli Mullen versus Union Territory of Delhi. The answer is A. Nas Foundation versus Government of NCT Delhi. Question number 35. Match list 1 with list 2 and select the correct answer using the codes given below the list. A. Reservation in unaided private colleges. It is PA Inamdar versus State of Maharashtra. Option B. 27% for OBCs in the government services. Indra Sawhney versus Union of India. That is option 4. Constitutional validity of the laws included in 9th schedule. IR Koilo versus State of Tamil Nadu. Next question. Match the following correctly. Keshwananda Bharti versus Union of India is 1973. Indira Gandhi versus Rajnarayan 1975. Minerva Mills case is 1980. And State of Bihar versus Bal Mukund Shah is 2000. Next question. In which case Justice Bhagwati propounded the new doctrine of equality? A. Air India versus N. Mirza. B. Pradeep Jain versus Union of India. C. E.P. Royappa versus State of Tamil Nadu. D. D.K. Basu versus Union of India. The answer is C. E.P. Royappa versus State of Tamil Nadu. Question number 40. A law which disqualifies a person with more than 2 children from holding the post of Panch or Sarpanch is valid and not violative of Article 14 of the Constitution. In which of the following cases the Supreme Court held this? Option A. PUCL versus Union of India. Option B. Javed versus State of Haryana. Option C. Indra Jaising versus Registrar General. Option D. Muhammad Aslam versus Union of India. The option is B. Javed versus State of Haryana. Question number 41. Alienation of natural resources is a policy decision and the means adopted for the same are thus executive prerogatives. However, when such a policy decision is not backed by a social or welfare purpose and precious and scarce natural resources are alienated for commercial pursuits of profit maximizing private entrepreneurs, adoption of means other than those that are competitive and maximize revenue may be arbitrary and face the wrath of Article 14 of the Constitution. It was held by Supreme Court in A. In re special reference number 1 of 2012. B. Center for Public Interest Litigation versus Union of India. C. Subramaniam Swamy versus Union of India, Ministry of Law and others. D. Common Cause versus Union of India. The correct answer is A. In re special reference number 1 of 2012. Next question. Excessive reservation would be fraud on the Constitution of India was observed by Supreme Court in A. Balaji versus State of Mysore. B. Indra Sawhney versus Union of India. C. Devadasan versus Union of India. D. Ajit Singh versus State of Punjab. The answer is A. Balaji versus State of Mysore. Question number 43. In which of the case it was observed by Hon'ble Supreme Court that we cannot agree with the view taken by the Union government that Jats in the 9 states in question is a backward community so as to be entitled to inclusion in the central list of other backward classes for the states concerned? A. Mansoor Alam versus State of Uttar Pradesh and another. B. Ram Singh and others versus Union of India. C. Deepak versus State of Haryana. D. Kesha Singh versus Union of India. The correct answer is B. Ram Singh and others versus Union of India 2015 Supreme Court. Question number 44. Reservation should benefit only those who belong to a scheduled caste or scheduled tribe and not those who claim to acquire the status by marriage. In which one of the following cases this view was expressed? Option A. S. Pushpa versus Sira Changamwa Vehi 2005. Option B. Punit Rai versus Dinesh Chaudhary. Option C. Shobha Haimarati Devi versus S.G. Swamy. Option D. Secretary State of Karnataka versus Uma Devi. The correct answer is option C. Shobha Devi versus S.G. Swamy. Question number 45. In which of the following cases the Supreme Court held that the constitutional amendments by which Article 16 Clause 4A and 16 Clause 4B have been inserted flow from Article 16 Clause 4 and do not violate the basic features of the Constitution? A. Indra Sawhney versus Union of India. B. Union of India versus Virpal Singh. C. M. Nagaraj versus Union of India. D. Ashok Kumar Thakur versus State of Bihar. The answer is C. M. Nagaraj versus Union of India 2007. Question number 46. Which one of the following judgments deal with service condition? A. Air India versus Nargis Mirza. B. Javed Ahmed versus State of Maharashtra. C. Madhu Kishwar versus State of Bihar. D. Usman versus State. The answer is A. Air India versus Nargis Mirza. Question number 47. Requirement of reasonableness runs like a golden thread through the entire fabric of fundamental rights is held in A. Keshwananda Bharti versus State of Kerala. B. Indra Sawhney versus Union of India. C. Vishaka versus State of Rajasthan. And D. Maneka Gandhi versus Union of India. The correct answer is D. Maneka Gandhi versus Union of India. Question number 48. After which one of the following decisions of the Supreme Court was the special provision for socially and educationally backward classes introduced by an amendment of the Constitution? A. Balaji versus State of Mysore. B. State of Madras versus Champakam Dorairajan. C. E.P. Royappa versus State of Tamil Nadu. D. Periya Karuppan versus State of Tamil Nadu. Answer is B. State of Madras versus Champakam Dorairajan. Question number 49. Backward and more backward classification is not bad under Article 14 was held by Supreme Court in which of the following case? A. Aarti versus State of Jammu and Kashmir. B. State of AP versus USV Balram. C. State of UP versus Pradeep Tandon. D. Balaji versus State of Mysore. The correct answer is D. Balaji versus State of Mysore. Question number 50. Which of the following case is popularly known as Hon'ble Case? The correct answer is C. Indra Sawhney versus Union of India. Question number 51. Which of the following is popularly known as bearer bond case? A. Indian Express newspaper versus Union of India. B. D.S. Nakara versus Union of India. C. R.K. Garg and others versus Union of India and others. D. State of Maharashtra versus Madhukar Balakrishna Badiya. C. The correct answer is C. R.K. Garg and others versus Union of India and others. Question number 52. A high caste Hindu female marrying to scheduled caste boy not entitled for reservation under Article 15 Clause 4 and 16 Clause 4 was held in A. Indra Sawhney versus Union of India. B. Dr. Nilima versus Dean of PG Studies, AP Agriculture University. C. Meera Kanwaria versus Sunita. D. Anil Kumar Gupta versus State of UP. The correct answer is C. Meera Kanwaria versus Sunita. Question number 53. Community or caste-based reservation in medical and engineering colleges was held to be void by the Supreme Court in which of the following cases? A. Maneka Gandhi versus Union of India. B. I.C. Golaknath and others versus State of Punjab. C. State of Madras versus Champakam Dorairajan. And D. None of the above. The answer is C. State of Madras versus Champakam Dorairajan. Question number 54. In which of the following cases the Supreme Court held that the equality clause cannot be applied to legitimize an illegal action? A. UP State Sugar Corporation Limited versus Sant Raj Singh. B. Vishal Properties Private Limited versus State of UP. C. Ekta Shakti Foundation versus Government of NCT Delhi. D. Bhagwan Das versus Punjab State Electricity Board. The answer is option C. Ekta Shakti Foundation versus Government of NCT Delhi. Question number 55. In which of the following cases the question regarding reservation is considered by the Supreme Court first time? A. Mandal Commission case. B. Romesh Thapar versus State of Madras. C. Champakam Dorairajan versus State of Madras. D. M.R. Balaji case. The correct answer is option C. Champakam Dorairajan versus State of Madras. So far we have discussed the questions related to right to equality of fundamental rights, Constitution of India. In the coming videos we shall discuss the further topics of fundamental right. Thank you for watching. Please like, share and subscribe our channel. Thank you.